Hello, good afternoon, everyone. This is Adil Farooq, and you are watching Legal Lounge with Adil Farooq by Adil Law Professional Corporation. Thank you for watching my logs, my small quick reels on the different topics of law in Ontario. And also thank you very much for your feedback on my presentations and your questions, which I tried my best to respond in my different logs and different reels. And today is a very important topic. Today I will talk about a lawyer's role in a real estate transaction, because in the last session I talked about the agreement of purchase and sale. I gave you details that how you look into the agreement of purchase and sale when you are dealing with your real estate agent to draft that real estate agreement. Before I start, this is a standard disclaimer that this session is only for information purposes. Please do not apply this conversation on your certain circumstances. You should take a legal presentation or legal opinion from your lawyer before you take any action in your specific matter. You can always contact with us to take any input on your legal matters relating to real estate transaction and other fields of law. So coming back to the session, today we will talk about the lawyer's role in Ontario in a real estate transaction. So once we receive the copy of the agreement of purchase and sale from you or from your real estate agent, we have the responsibility to have a quick look of this agreement of purchase and sale, and if there is any discrepancy or any issues, legal issues which we solve that have been missed, we will just guide you about that and try to guide you that how to resolve that issue if those issues are resolvable. But always remember that once you sign the complete agreement and waive all the conditions, there is very unlikely that the other party will allow you to amend anything in the agreement of purchase and sale. That's why I always recommended to ask your real estate agent to pay special attention to different clauses which protect your interest, whether you are selling or you are buying. Okay, so once we receive the agreement of purchase and sale, we open the file and then we start working on it. I will start with the purchase aspect. If you are a purchaser in a real estate transaction and we receive your agreement of purchase and sale, let's say your date of closing is 1st of July 2026 and your requisition date or title search date is 15th of June 2026, which is at least 2 weeks before the date of closing. So we, being a lawyer, open the file before that and we do our title search and execution searches against the existing owners of the property, and we have the responsibility to send a requisition letter to the vendor's lawyer. And that requisition letter means that if there are any legal issues, if there are any procedural issues, any problems in the property, we have to notify to the vendor's lawyer and to give them the opportunity to fix those issues and address our concerns in that real estate property. For example, if there are outstanding mortgages on the property which you are buying, so we, being a lawyer, have the responsibility that we make sure that the previous owner or like the vendor's lawyer take care of this thing and pay the previous owner's mortgage on the property from the sale proceeds they will receive from our office. On top of it, if when we will do the title execution searches for the existing owners of the property, if there are any executions against the owners, we also notify to the vendor's lawyer and they take care of those executions, and there are certain ways to deal with that, which is not a buyer's responsibility. It's seller's lawyer's responsibility to take care of those things. So there are many other things. If you saw there's a violation of Planning Act, we notify them about that violation. If there are any easements or any right of ways or any liens on the property, we deal with that during that process. When I say liens, just for your knowledge, recently in Ontario, that any liens from different companies, those who have for example, hot water tank or furnace or any kind of fixtures on your house, and they have the lien, we are allowed to remove that lien and there's certain process which the seller's lawyer will do that, but it doesn't mean that these things have been paid off. So we have to make sure from the vendor's lawyer that they pay off those liens which are attached with this property because of any unpaid furnace or a hot water tank on the property. If you are not assuming those things, if you are assuming as a buyer, then they will not going to pay, but they will still remove those liens from the property. So we will do all those searches, and then we send the requisition letter to the other lawyer, and other lawyer took their time and they address all those concerns which we raised before the date of closing. And in the meantime, if you are taking the mortgage, which is most of the clients are taking the mortgage in Ontario to buy the property. So after a few days before closing, we usually receive mortgage instructions from your lender. Because if you should contact with your mortgage broker once you firm your deal, or before actually you waive your condition of the mortgage on the agreement, and you work with your mortgage broker or with your bank directly and tell the bank that who is your lawyer. So your bank will do internal works and they will send the mortgage instructions to your lawyer, and the lawyer will comply with all the conditions imposed by your lender on the funding. So if there are certain conditions, for example, if the bank want us to pay any of your existing loans, which usually line of credits or credit cards or previous loans, they instruct us that we make sure that your previous loan has been paid before they or from the procedure of the mortgage, so they can disburse the funds on the date of closing. So whatever the requirements of the bank, we complied with those requirements. And one of the basic requirements is that banks need your signed documents before the date of closing. Excuse me. Not all the banks need those final documents before the date of closing, but few does. So we have then few days before closing, we will request you guys, the buyer, to attend our office to sign the documents. But before that, we put all the figures together, which includes that your payment to the sellers, your payment towards the land transfer tax, any payments towards your loan which the bank want us to pay, our legal fees and disbursements, any mortgage broker fee which you promise to pay them, the land transfer tax which you need to pay them during that process as a buyer, and title insurance. We will put all the figures together and see how much you are getting from the bank. For example, if you buy a house for 1 million and you have $1,050,000, for example, you have already paid $50,000 down, and then the bank is giving you only $800,000. So it means you are short of $200,000 plus the land transfer tax, title insurance, and our legal fee. So we'll calculate all those figures, and before you attend our office, we'll send you an email with the details that you should bring this certain amount of money with you when you are attending our office. So you attend our office a couple of days before the closing, and we will explain you each and every document you are signing and answer the questions, and we took all signature of all of your documents. And we 100% make sure that always myself or one of my lawyers attends you to do this process. We don't leave this process on our real estate clerks, and because we want the clients to understand their rights and obligation during that process. So once you sign the documents, that will happening 1 or 2 days before, and once you drop the money to us on the date of closing, the bank sent us the money, which is in the morning of the closing. It depends which bank you are dealing with. Some banks send early morning, some banks send by the noon. So we usually receive them funds before 1 or 2 o'clock in our bank account from the bank, or sometimes bank want us to go to their branch and pick up the funds. So whatever the situation, we comply with that. And on the date of closing, we already have your funds, we have your signed documents, we have the funds from the other lawyer, and we put everything together, all the funds in our trust account, and send the required funds to the vendor's lawyer. So once the lender's lawyer received the funds, they gave us the permission to transfer the property electronically under your name. And the moment we transfer the property under the buyer's name, the buyer become the owners of the house, and at that time the vendor's lawyer release us the lockbox number. They don't send us the keys anymore, which used to be. and the law and the vendor's lawyer sends a lockbox number, and we send this lockbox number to our client. The moment we send the lockbox number to our client, which means they become the owners of the house. During that process, we also inform you that it's your responsibility to set up all the utilities under your name effective from the date of closing. You have to arrange home insurance effective from the date of closing. Remember, if you fail to do those things, first of all, if you don't have the insurance, the bank will not release the fund. That's mandatory. If you are buying any freehold kind of house, and if you forget or fail to transfer the utilities under your name, the sellers or vendors, they will cancel their accounts. And if you fail to do that, the utility companies, they will disconnect your utilities and they will impose penalties on you to reconnect those utilities. So make sure you call all the utilities way before the date of closing, so notify them that from that effective date, the date of closing, you will be the new owners of the house. So once we give you the keys, you will the owner, you go ahead and take the possession of the house, and that's all from the purchaser's point of view. So from the vendor's point of view, the vendor's lawyer, when the lawyer, as a vendor's lawyer, we receive the mortgage, we receive the agreement of purchase and sale. We request our client to send us the property tax bill and the details that how much property tax they have paid until now, and also we want them to give us the details of any existing lien or mortgage on the property. So once we receive all those information and we know that date of closing is 30th of July, and we send a request to the existing lender, tell them that we are closing the deal on 30th of July. Please tell us how much money our client owe you to give us a discharge of the existing mortgage, and they will send us that information. And also, once we have your tax statement or tax detail, property tax details, we will adjust that in the statement of adjustment. If let's say if you are closing on the end of July, and you have already paid the property tax quarterly, and you already paid until September, it means you paid a little bit more than what you're expecting to pay. So in the statement of adjustment, we tell the other lawyer, the buyer's lawyer, that our client has already paid more than that, and they will give that money back to us. And the same rule applied to the condo fee. If you pay the condo fee for the month and you are not responsible, we will get it back from the buyer as well. So we also advise the sellers to call all the utilities to give them notice that you are selling the property on that certain date, so they cancel all of your utilities. And also we tell them to cancel your insurance or anything you are paying monthly attached with the house. You have to take care of this thing. So these all things we inform the client, and again few days before closing we ask the client to attend our office, and we will take care of execution of all the documents, explain all the funds. In the funds detail, we always tell them that what's your sale price, what's your deposit with the real estate company, and what is your existing mortgage amount, what is payment of any other lien if it's a house you have to take care. If there's any execution against the seller's name, we have to deal with that, and if there's an expense to deal with that, we will tell them. And besides that, there's a real estate commission. If your real estate commission is more than whatever your deposit given to the vendor's realtor, then we have to pay that commission part of that. If the deposit by the buyer paid more than the commission, you will get directly from the real estate company the balance of your money after deduction of the real estate commission. So on the date of closing, you vacate the house, you clean the house, and then you will leave everything in the house what you promised in the agreement of purchase and sale. I always suggest my clients and everyone who talk about the real estate, please go through the list of items which is you added on the second page of agreement, or in the schedule B, that what included in the sale price. If you mention that you are giving them the 2 fridge, 2 washer dryer, 2 stoves, 2 microwaves, blah blah blah, all those things should left behind in the house. I dealt many times with that. When the clients come to me, I show them, okay sir, you have to leave those things behind. And when they say, oh, we don't have the microwave, how come I'm leaving the microwave behind? That's too late, because that's your real estate agent responsibility and your responsibility to check that what you are selling with the agreement. And once you assign something, you are liable to pay. The same thing happened with sometimes with the garage door openers. Sometimes clients say, oh, we're saying garage door openers, but I don't have a garage door opener. So unfortunately, if the buyer insists, you have to install the garage door opener, or you have to leave that microwave behind if that's part of the deal. But if it's not there, then you don't need to worry about that. So on the date of closing, you actually, before that, you will give us the lockbox number, and on the date of closing, once we receive the money from the buyer's lawyer, we will allow them to transfer the property under their client's name. So once we release that lockbox number to them, we notify our client that no more, you are not the owner of the house, so please don't go back to the house because you are no more owner of the house. I understand that sometimes it happens when you are selling a property, you are still in the process of moving out, and the new owner comes to the property saying, oh, I'm the new owner, why are you still here? So I will suggest, please coordinate with each other and give each other some time as a courtesy to let them remove everything from the house, and then you will take off the property. So this is a very basic concept, very basic things which is happening behind the scene, and most of the buyers and sellers don't know what the lawyer are doing. But you should rest assured that we take all necessary steps to make sure that your deal will be closed smoothly on the date of closing. Sometimes happen the buyer failed to arrange their mortgage and they request for extension. In that case, we being a seller's lawyer receive a request for extension, and if we are willing to give them an extension, we advise you about your possible damages and about your rights, that what you can claim from them, and we will tell them, okay, this is a date, these are terms of extension, and if they agree to those terms of the extension, we proceed accordingly. So I believe that's all for now. It's already been 17 minutes. I usually try to be under 15 minutes. So but if you have any question, feel free to call us or contact our office about any matter, real estate matter or other legal issues, and we are always here to help you. Thank you for watching Legal Lounge by Adil Law, and I will see you next Tuesday same time with another interesting topic. Until then, take care of yourself. Bye bye.